Chapter 3, Legal Issues, Part 1. There are various legal constraints on the police. Criminal procedure is first and foremost among these. What is criminal procedure? Well, in general, we're referring to the laws that govern the government during the criminal process. And so, although we'll focus mainly on the police, criminal procedure also applies to prosecutors, the courts, corrections, etc. At each stage in the criminal process, all the way from suspicion, through trial, through or plea bargains, through sentencing, through the actual punishment, there are various criminal procedural rights. So at each step in the system, in the process, there are various protections and requirements that must be observed in order to properly adjudicate a case. What are some of the sources of criminal procedure? Well, most people, when they think of criminal procedure, probably think of their basic rights. And these rights are typically found in constitutions, whether they be federal or state constitutions. Each state in the United States has a constitution. We often only think of the U.S. Constitution, but every state has a constitution. And for the original 13 colonies, their constitutions predated the federal constitution. One of the chief sources of criminal procedure, and probably the most well-known, would be the Federal Bill of Rights. We'll talk more about the Federal Bill of Rights as we go along throughout this particular lesson. There are also statutes that can dictate what the rules of evidence are and what are some of the requirements during the criminal process, and those can be found in statutes and rules and places like that. They're typically drawn from some of the constitutional provisions, but they also are sources of criminal procedure in and of themselves. And for those of you who are interested in going on to law school, you're going to study a lot of court opinions, because the courts will interpret what some of these constitutional clauses mean, what the various statutes mean, and so court opinions are also a valuable source and a very fundamental source of criminal procedure. How do we actually apply criminal procedure? Well, Herbert Packer, a famous legal scholar and criminologist, suggested that we could really approach criminal procedure with two different models of criminal justice. And he called these models the due process model and the crime control model. So both tried to characterize different extremes of the criminal justice system. And each has its own focus and emphasis on different characteristics of the criminal justice process, and they operate differently to arrive at what we would call justice. The due process model focuses mainly on the rights of the defendants. So it says that the main purpose of the criminal justice system is to protect the rights of the defendant. Crime control, on the other hand, says the main purpose of the criminal justice system is to protect the safety of the community. So the focus is more on the community than on the criminal defendant. Under the due process model, the emphasis is on trials, especially trying to minimize plea bargains and guilty pleas. And so the due process model really encourages defendants to fully use all of their rights to put the government to the full test of its evidence and of its persuasion before the defendant will be found guilty. So the due process model is really characterized as an obstacle course. The government has to jump over hurdles every step of the way. The police have to respect the search and seizure rights of the defendant. So they must respect the privacy of the defendant, even though it would be easier to get criminals if they could ignore those. Under the due process model, the government must respect those rights. It must respect the defendant's right to remain silent. All these kinds of rights that we're going to discuss a little later. The prosecutor must respect rights. The courts must respect all these rights. The whole system under the due process model is set up to protect the rights of the defendant. Under the crime control model, there is less emphasis on protecting the rights of the defendant. Why? Well, it's because we believe that we can trust government. The government isn't comprised of ill-intentioned people who are evil. Instead, it's comprised of people who are mostly diligent and they respect the law, and we should trust them. And so therefore, the system works better as an assembly line. Let's process as many criminals as possible because that'll better protect the community. Let's not encourage trials. Instead, let's encourage guilty pleas. Why? Because most of the time, crimes aren't that difficult to understand. There aren't a lot of questions of facts. We know who did it, probably because the police observed it. And so, in a typical DUI case, do we really need to take that to trial? Probably not in most instances. So under the crime control model, they really encourage guilty pleas and quick justice. Let's move as many people through the system as possible. So the due process model is best characterized as adversarial, meaning the system works best when the prosecutor and the defense attorneys diligently oppose each other, and we have a neutral party, the judge or the jury, being basically the referee in the case, having no bias, listening to the facts, listening to that kind of legal combat that's going on in front of them between a diligent defense attorney, diligent prosecutor, and arriving at the truth by hearing both sides of the stories. The crime control model is much more focused on cooperation. Crime control model views the participants in the criminal justice system as more a courtroom work group. The prosecutor, the defense attorney, the judge, they basically work together more than against each other. Because although there may be trials from time to time in the crime control model, mostly, again, they're not needed. And the participants have a pretty good idea, because they've been doing it for a long time, what the appropriate outcome for a DUI case should be, or a simple assault case, because they've done hundreds to maybe thousands of these. So they pretty much have a good idea of what should be the proper outcome. So therefore, they don't need to oppose each other. Instead, they can cooperate, have plea bargains, really process a lot of people through the system. In practice, I think we're more crime control model than we are due process. In theory, if you looked only at the U.S. Constitution and the Bill of Rights, you would say we're much more devoted to due process. I think in practice, we're much more crime control. Well, if we look at some of the other considerations for criminal procedure, we come across federalism and incorporation. Federalism is a term that applies to our system in which we have both state and federal systems coexisting, but they're really separate. So they have a lot of similarities, federal and state criminal justice systems, and that's especially true as a result of some changes that we're going to discuss in a few more PowerPoints a little bit later, when we discuss the due process revolution in the 1960s. But the state and federal systems are still separate. They can be different, but they do coexist. So when you're in Pennsylvania, you have Pennsylvania laws applying, the Pennsylvania Constitution, but you also have, obviously, the federal Constitution and federal laws. When there's a conflict between state and federal laws, the U.S. Constitution says federal law is supreme. So we'll talk about this with the Bill of Rights and the due process revolution in the 1960s, when the U.S. Supreme Court forced some changes upon the states when it comes to the police and also other aspects of criminal procedure in the criminal process. The Federal Bill of Rights, as we said earlier, are an important source of criminal procedure. They are the first 10 amendments to the U.S. Constitution, and they were ratified in 1791. The original U.S. Constitution was ratified in 1788. It was debated and written in 1787 and then ratified in 1788. But there was an agreement in 1787 that if the original Constitution was passed, which it was in 1788, then soon after, the Founding Fathers would attach a Bill of Rights. They didn't know exactly what rights they would include at the time, but eventually they settled on the ones we find in the first 10 amendments to the Constitution. Now, these weren't meant to be the only rights we have, but again, they're obviously an important source of various rights, from freedom of speech all the way through criminal procedural rights. The great majority of them deal with criminal procedure, to be perfectly honest. But again, they were ratified in 1791. There were already state constitutions, as we've already mentioned, that were already in place. So we'll figure out how the Bill of Rights and the state laws and constitutions worked throughout our history. Were the states always required to follow the Bill of Rights? We'll find out that that wasn't always the case. Was the federal government always required to follow all the Bill of Rights? Yes, that was a pretty easy one. So we'll discuss some of this. As I said, the Bill of Rights contains numerous criminal procedural protections. We're going to cover the ones that apply to the police. Incorporation is a doctrine that we're going to cover in the next PowerPoint, and it's a difficult one. It's a complicated one. It's hard to understand. We'll try to understand it. But it basically asks who must obey the provisions of the Federal Bill of Rights. And we'll find that there's an important amendment that's passed in the 1860s that makes us consider whether it incorporates the Bill of Rights and makes them apply to the state governments. If you don't understand it yet, we're going to go through the process. If you're a little bit confused, just bear with me. We're going to cover incorporation in the next PowerPoint lecture.